Assalamualaikum warahmatullahi wabarakatuh. This is part 2 for the lecture of the topic agreements in restraint of trade. So in part 1, we have covered up to the case of Wrigglesworth and Anthony Wilson, in which it applies issues to us application of section 28. So now we are going to continue with another subtopic, which is what if the restraint, Right. What if the what if the restraint here is in respect or in relation to confidential information or trade secrets? Is it still being caught under section 28? Is it considered as restraint, which is void and not enforceable? So this issue was actually addressed and was resolved in the case of Schmidt Scientific Numberhard and Ong Han Swan, 1997. In this case, this is the ratio. The court held that to restrain employees from using, disclosing, or divulging confidential information and or trade secrets of their former employers to their detriment is not a restraint of trade. Meaning that here, if the employee, after he resigned, okay, after he left the employment, and then he want to disclose some confidential information, so it doesn't amount to restraint of trade, maybe it is void under section 28. So as far as those specific situation is concerned, it's not considered as restraint of trade. After all, he's not being restrained of practicing his profession. He's just being restrained from disclosing confidential information. So allegation of restraint of trade fail in that case. So that's basically the rule that we can extract from this case. So whenever the restraint is pertaining to confidential information or trade secrets, then it is not caught by section 28. We cannot apply section 28 to make it void. So basically it is valid. So the employee can be restrained in that sense. Okay, another issue is in respect of negative covenants, or it is also known as exclusive service contract. A contract in which you the person is bound to serve another person, usually the employer, exclusively. Okay, so the rule pertaining to negative covenants here is that negative covenant, it operates during the period of the employment contract. That is when the employee is bound, is obliged, legally obliged to serve the employer exclusively. So usually when the employee agreed to be employed by the employer, signed the employment contract, so he is bound, legally bound, duty bound to serve his employer exclusively, cannot work elsewhere without the employer's consent. So this is what we call as negative covenant. Here you are being prohibited from working elsewhere. You are being obliged, you are made obliged to serve your employer exclusively. So in that particular situation, it's not considered as restraint on the part of the employee. Okay, so such covenants, the employment contract here, are not regarded as restraint of trade, and therefore we don't apply section 28. It's not caught by section 28. And then the case to explain this issue is polygram records Numberhard and the search. If you still remember, we discussed the case under the topic of undue influence. So one of the grounds, which was forwarded, which was used, which was relied on by the party here, by the search, when they were being sued by the recording company, Polygram Records, was that they were being restrained from recording elsewhere. So whatever term which restrain them, actually it is what under section 28. But Bisu Sinadurai, the judge, held that section 28 actually was only applicable to cases where a person was restrained from carrying on his trade or profession in the post-contract period, and it doesn't work. It's not applicable during the currency of the contract, during the subsistence, during the existence of the contract. So if you are still the employee of that particular employer, you can be restrained. But after you left the employment, meaning the post-contract period, then you cannot be restrained. There are two different stages or situation here. First, during currency of the contract, and another one is post-contract period. So section 20 is only applicable for post-contract period. Meaning that here it's not, the employer cannot restrain the employee after the employee leave the employment. But during the currency of the contract, because the employee is the one who paid the salary whatsoever, so employee can be legally restrained. It doesn't amount to restraint under section 28. Okay, so the court held that the covenant, okay, the agreement whereby the defendant undertook, okay, promise to provide exclusive recording rights to the plaintiff during the currency of their recording contract is not a covenant in restraint of trade, and therefore it's not rendered void under section 28. So it's still valid, okay, when you are still bound, okay, by the contract. Okay, after you leave that that particular company, then only you can apply section 28. So basically, why the issue was relevant? Because the search, okay, when they were being sued by Polygram Records for breach of contract, because they are not happy with the royalty rates whatsoever, and they decided to do the recording elsewhere, actually under their own company. So basically, they said, okay, when they are being sued, they said no, we are being restrained from recording elsewhere. So the restraint is what? But basically, because they are still bound, okay, by the contract that they signed with Polygram Records, they are still the artists under Polygram Records, so they can be restrained. Okay, right? So basically, whatever contract that they have signed, actually, it was valid. It's not cut by section 28. Okay, now let's have a look at position under English law. Okay, because why? In most of the situation, in most of the topic, usually we adopt English law. But as far as restraint, agreements in restraint of trade is concerned, we don't apply wholly. Okay, we don't apply every single things of the rule, especially in respect of the rule relating to reasonableness. Okay, let's have a look what the position under English law. All contracts falling within the doctrine of okay, are contrary to public policy and prima facie void. So basically, yes, they are void, but we have the word prima facie, meaning that here, unless they can be regarded as reasonable. So it's still possible to be valid provided it is reasonable. Okay, meaning that here, the prima facie void is subject to the proof or evidence to the contrary. It is something which is rebuttable. So reasonable as between the parties and as regards to public interest. Reasonable between them and reasonable for the public interest. So now, how to determine the restraint is reasonable? So the burden of proving that, okay, between the parties, restraint is reasonable, lies on the promisee, meaning that the party who restrain, and the burden of proving that as far as the public interest is concerned, the restraint is unreasonable, lies on the promisor. Usually the promisor is the defendant, okay, the person who signed and then agree to that the restraint is imposed on him, okay, the party who is being restrained. And then here there are two aspects of reasonableness here. Is it reasonable between them? Is it reasonable for the public interest, okay, for the interest of the public? And then in respect of the time, okay, at what point of time you want to consider it is reasonable? Reasonableness is considered as at the time of the agreement, and then restriction must be reasonable as regards to area and duration. Okay, let's say we apply the restriction, okay, in respect to the case that we discussed earlier, which is the case of Rigoso and Anthony Wilson. You remember, okay, restriction is only for 2 years, okay, and only in respect of 5 miles, okay, from Kota Baru town. So it's still reasonable, isn't it? Okay, but then we don't apply the concept of reasonableness here, okay, for that particular case. But under English law, we have to see, is the restraint reasonable or not? So the case in which the concept of reasonableness was applied was the case of Fish and the Woods. This is common law, very classic case, 1921. And then what is the restraint here? A lifelong restraint for the whole lifetime. Okay, on whom? On the solicitor's managing clerk. Okay, and then what's restraint all about? Not to work within 7 miles of Tamworth, certain location here, small town actually, was held to be reasonable in the circumstances. Despite the fact that the restraint is for a lifelong restraint and then cannot work within 7 miles, but the court in that particular situation at that particular time, okay, held that yes, it was reasonable. It's okay for the former employer to restrain this managing clerk, okay, to put such a restraint. So what was the reason of holding those covenants as valid? Because why? The court looked at the facts here, okay? Because the former clerk, if allowed to practice within several months in the area, okay, of temple, okay, might severely affect the practice of his former employer. Okay, if utilized, because he's very experienced, okay, he has so expertise, very skillful. If he utilized his knowledge of clients, so he got to know so many clients here, okay, and their affairs to attract them as his own client. So it might affect the business of the former employer if the employer allow him to work within 7 months of employment. But again, if we were to apply this case nowadays, okay, maybe the judgment might be different. So this case is exceptional because why? Especially the emphasis on the lifelong. So usually it's not really reasonable to put lifelong restraint on someone. Okay, all right. So it may not be followed today. If we have similar facts today, maybe the decision would be different. It could be invalid rather than valid in that particular case. We have another case in respect of reasonable or not. Reasonable, the concept of reasonableness here. The case is Nordenfeld and Maxim Nordenfeld Guns and Ammunition Company Limited. Also a very old case here, 1894. This is appeal case and judgment by House of Lords. So House of Lords states and apply the basic rule here. So what's the rule later? So we look at the facts here. Who was Nordenfeld? Nordenfeld is the plaintiff. He was the one who challenged the validity of the restraint clauses imposed on him. So Nordenfeld, he was an armament. Armament is military weapon. Armaments manufacturer, and he sold his business to a company. The company name is Maxim Nordenfeld. Meaning here they are using the same name. I mean, he sold off his business together with the goodwill, I believe here. Okay, Maxim Nordenfeld Guns and Ammunition Company Limited. So he sold his business to this company. And then, as part of the sale, he agreed to the following restraint, meaning that he have, in order for the sale to take effect, so he signed the agreement here, and it contained these clauses. He challenged it later. Okay, in this case, he agreed that he will not, okay, for 25 years. So duration is 25 years. So he agreed that, okay, he will not be engaged, okay, except on behalf of the company, either directly or indirectly in the trade or business of a manufacturer of guns, because that's his expertise, expert area. Gun mountings or carriage, all the weapons, gunpowder, explosive or ammunition, or in any business competing or liable to compete in any way with that for the time being carried on by the company. So basically, if we were to divide the parts of, the clauses here, it's possible to be divided into two parts here, especially the first part is 25 years, okay, blah, blah, blah here, and then or from here, or in any business. This is the second part, in which this is actually the focus here. Okay, and the court actually the court examined the whole thing, and then the court came to the conclusion, okay. The court said, well, since the business was worldwide, this is international, okay, restraint, okay, if valid, then it was also worldwide, meaning that if the clauses is valid, so the effect is that it is worldwide, okay, imposed on Nordenfeld here, the plaintiff. So House of Lords laid down the following principles. A restraint of trade clause is not void, but only prima facie void. So it's still possible to make it valid. That means that the burden of proof lies on the party seeking to uphold the clause to show that it is valid. And if that party fails to discharge the burden, then the clause is void. So it's up to the party who put the clause here, whether it is actually void or valid. So the party seeking to uphold the clause discharge the burden of proof by proving to the court that restraint is reasonable in the interest of the parties and in the interest of the public. And then House of Lords apply this. Okay, how to know it's reasonable or not? Okay, the court said, well, you have to prove that the clause protected legitimate interest. That's why you put on the restraint clauses. And House of Lords held that the clause, yes, we agreed, did reasonably protect the company proprietary interest, except for the final phrase. Remember the part 2 of the phrases, okay, especially the word, any business competing or liable to compete in any way with that for the time being carried on by the company, which is too broad here. It's not really reasonable, that part of the clauses here. So this clause impose an unreasonable restriction on a default, which is actually not fair, basically here, not really reasonable, unreasonable. Because why? Yes, it is acknowledged that his expertise and reputation was in armament. That's why he decided to let go, okay, sold off the business here. But if he became an antique dealer and the company later diversified into antiques, then, okay, read literally, okay, hold on for a while. I need to, the battery is weak. Sorry for the interruption. Okay. Sorry for the interruption. I need to plug in the charger. Okay. All right. So coming back to the case, okay, not fault. His expertise and reputation was in armament. So the court take note of that part. Okay. And then the court say, well, if he became an antique dealer and the company later diversified into antiques, okay, then, so read literally, the clause could restrain him from practicing his new trade. Because why? In any business competing with the company. So meaning that he cannot start any business, even though it's not really related to armament or weapon here. So the House of Lords eventually finally held that this part of the clause was merely to protect the company from free competition. So free competition, which is not a legitimate interest. So we don't want you to impose that clause on the plaintiff, not the fault here. But then this part of the agreement, okay, actually can be severed. Remember, okay, we learned about remedy of sever, okay, could be severed, could be cut from the rest of the clause. So that's why the rest of the agreement was valid. Only the ending part, so that one we just cut it, okay, cut it off. Okay, we stop here. We are going to continue later. Okay, what's the concept of reasonableness under Malaysian law or Contracts Act 1950? Okay, all right, let's stop share first. All right, thanks a lot for listening. Okay, we'll continue in part 3 later. Assalamualaikum warahmatullahi wabarakatuh.